My lords, in
Item 26, the matter is coming on first week of the August.
my lords, that is why this was this application filed. Now,
They have concealed the order of this honorable court.
My lords, I am sorry, my learned friend will just
Yeah,
allow me. I find this little strange. So, my lords, in item number 26, I had filed an application for appropriate directions in that particular matter. Now, if my lords may take my application first in item number 26. And my lords were pleased to issue notice in the SLP, and my lords will find the order of this honorable
No,
court.
now this court had said it is to be listed in August, is it
No,
not?
no, my lords, that's all right.
Same prayer
What
you are
is-
seeking in
No,
the.
I am on something
before the
very
High
different.
Court.
No, my lords, that is where I beg
That
to
is
submit.
That's
What the High Court
cost,
observes. But that is,
cost has also been imposed
my
because
lords,
of
that is where I say it is factually incorrect what the High Court has observed. If my lords may only see my prayer, which I had made in that application before my lords. My lords, just 2 minutes.
Now the date has been given
My
in
lords, there is a
August.
problem. They are demolishing my full construction with bulldozers. I have filed that in at serial number 24.
But the same prayer you sought in the IA.
My lords,
There
no,
is no
that's where I
stay
beg
on
to
the
submit.
acquisition.
Yes.
The notice is only whether you will get compensation in terms of the value of when the 6-1 notice was issued, or as per 24 subclause 1
Of
of the new
2030.
act,
Or the old act.
Or the old act.
assessment
My
of
lords,
valuation.
may
That
I
is
just
all.
put in,
How
may
can
I?
you stop the
My
utilization
lords,
of the
please, just give me half a minute.
Possession has been taken.
My lords, that is where I
Therefore,
submit.
they-
My
they
lords,
have
the
allotted
demolition
third
of my
parties.
structure has to follow a due process.
No
There
due
is a
pro-
procedure that is prescribed.
What procedure once there is acquisition?
My lords, when you take over the possession and there is a structure which is standing now.
Did
there
you
is a-
participate in the award making process?
My lords, my instruction, I asked that specifically. They had no notice
No,
about
no.
it. They had no notice
Section 9
about it.
notice is there.
My
The
lords,
award
they
is
had-
passed.
They had no
More
notice.
issued
No, my
before
lords,
taking
they-
possession.
My lords, the award is of
Did you
2004.
participate in the award making process or not?
We did not because we had no notice about the
Can it
process.
be? Section 9 notice.
My
is
lords,
issued.
we did not have. Otherwise, we would have gone in. Now, please appreciate why I say this. My lords, just give me half a minute to explain. When I came before my lords on the 15th of May 26, what was being done by them was only to give possession letters without writing on the possession letters that the matter was sub judice before this court. So I came an application on 15th of May 2026 before my lords with that application. That application, my lords, while that application was not rejected, my lords kept that application together with the main matter. Now on 26th of May, they come with the bulldozers. They start to demolish all the structures. My lords will find all the
You
photographs.
could have approached this court instead of filing a separate writ petition.
My lords, therefore, my lords, now today, then they come with that. I go to the High Court only with the limited relief that the demolition must happen in accordance with due process of law. It cannot be demolished with
When
the
the matter
use
is
of bulldozers.
before the Supreme Court, why do you go to the High Court?
My lords, the
Same
only
thing.
I have not made the same prayers between the two. High Court non-suits me only on.
All these issues may be
Yes,
My lords,
they have suppressed the order.
Today, my IA,
Before the High
which
Court.
order, I don't understand.
You can advance your IA before this court and we'll set aside.
My lords, it is there.
We'll
Please take up item
No,
26.
We'll restrict the cost. Instead of 5 lakhs, we'll reduce it. You advance your IA from August to an earlier date.
But my lords, by then, if my lords may only give me half a minute. In item number 24, please turn to the photographs that I have attached.
No, we are not
Madam,
interfering.
At
We
best,
are not
at
interfering.
best, you will be entitled to additional compensation.
My lords, but
Nothing more than that.
my lords, please, otherwise how will we ascertain what's the nature?
No,
Just
no.
please turn. They are with the bulldozers out there.
If you can make out a case of no notice and violation of the
You
procedure established by law,
In the-
punitive compensations may be awarded by this court.
My lords, there's a functioning
But
petrol.
you cannot stand in the way of the development of the
My
land.
lords, only one aspect that my lords will consider, and I rested there. There is a functioning petrol pump. It's the only petrol pump in the vicinity.
That is irrelevant.
That's irrelevant. But a petrol pump cannot be dismantled without the oil company itself coming, removing the underground tanks, because otherwise it's extremely
That they will
hazardous.
do it. If we don't interfere,
lords-
they will do it. If we
My
interfere,
lords-
that will not happen.
My lords, but just in that context, please look at the pictures.
You
Look at
want
the
to, you
photographs.
want to involve, we can observe that the removal will be in consultation with the oil company. After taking the
My
oil
lords,
company in.
Can the demolition not be held up only
Oh,
at
no, no,
August?
never.
My
No,
lords,
not at all.
August is a matter. My lords, may please
seek
hold the matters to
advancement.
July. I'm
You
saying
seek
please hold and
advancement.
hear me. My lords, can I make one last humble prayer? My lords, may prepone my matter to July. Hear me, but just grant me a protection.
No, 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 will not. Otherwise, we'll adjourn this fresh case also to July, to August. If you want, we'll adjourn this fresh case to August, if you want that.
My lords, then I have an application at serial number 26. But there's no demolition in that.
11th November 24 order is very clear, Your Lordship.
No,
My lords,
this,
Therefore, my lords, I have an IA in that. Now, High Court observes my IA is
See,
rejected.
this,
It's not. My lords have
we-
kept it.
24 and 26, let both come together in August.
My lords,
We'll just
26,
adjourn both the
I am
cases.
only saying in 26, at least the demolition can be.
No, no, nothing.
Until. My lords, so far as the allottees are concerned, at least if my lords decide.
What is the date in August?
4th August. 4th of August.
4th. List will say. List
My lords,
this,
then only one last thing. So
list
far as
this,
my-
list, this is item 24, you say. List this SLP along with IA number 152903 of 2026. Filed in diary number 49027 of 2024 on
My lords, on 4.
48.
My lords, may
Yes.
please then observe that if this demolition is illegal, my lords will.
Nothing, that goes without saying. It goes without saying.
And my lords, so far as the cost is concerned.
That also you take it up before
my
that
lords,
bench only.
By that time, if
It
then.
was reduced from 25 lakhs to 5 lakhs.
My lords. if
What is the, within what time you have to deposit?
4 weeks, that is the order. So my lords may at least state the cost. My lords, I'm pointing it with all humility. The prayers are not the same. I filed my petition.
It's okay.
It's in the time.
To 10, it will say, time for payment of cost is extended till 10th August.
There.
Yes, 2026.
And my lords,
Both
my lords,
will
so
be,
far as item 26 is
both.
concerned.
We have passed that.
No, item 26, my lords have said it will come up on the date fixed, which is 4th of August. I'm only saying one thing, that they have started giving this so-called possession letters. If my lords were to
We are
decide-
not to make interfering in any other way.
I am only saying this, if my lords were to decide, I take it for a moment, I have a good case on merits and my lords can decide it in my favor. If that is decided, then at least these possession letters will be subject to the outcome of.
That
this.
goes without saying
My
any
lords, it's
step.
not returned.
See,
It
any
is
step
not
which they have
returned.
taken,
My
if
lords-
you are successful, any step which they have taken will go.
My lords may only
That
record.
goes, no,
My
no,
lords may only
that will happen if you are successful, not today,
My
not
lords,
today.
But the third
Thereby
party
getting
rights.
another injunction.
Sorry.
My lords, third party rights are being
It
created.
goes without saying, if you are successful, all third party rights will go.
My lords, but they are not put on notice.
You please bring it to the notice of the bench when you are successful. Yes.
My lords, but third party rights are being created today. And they are not being.
They are not before us to give an injunction
My lords-
against them.
One. Can I answer that?
Thank you.
Third party rights are being made by respondent herein without putting them on notice of pending SLP before my lords. All that I am requesting.
They are taking the risk. Don't worry, they
My
are
lords-
taking the risk.
My lords, they don't even know about the pending.
All right, they take a risk.
I am appearing for respond number 4 only.
My lords, therefore, now please appreciate.
No, we are not concerned
They-
about.
They
You need not be concerned about them. They are taking a risk. If you are successful, the risk will vitiate the entire thing.
I'm
Yes.
only saying that the third party rights be subject to the outcome